I checked in with Andy. She didn't have anything ready yet.
Okay.
Good morning, Mr. Warber.
Good morning.
Which case are you here for, sir?
Credit acceptance versus Alonzo Tagger. Peter Beck is the attorney on the other side.
I haven't seen Mr. Beck as of yet. My policy is 15 minutes after the scheduled start time.
No problem. I'll hang out.
Thank you. Marianne, we have a little bit of a lag between 9:15 and 10 o'clock.
Yes, we do.
And not, not sure how that happened.
I wonder
Not
why,
complaining,
yeah.
just-
You know, it's so funny because you think of that and then you think of last week when they're all at 9 o'clock. And then now, you know what I mean?
This is different. This was my scheduling stuff on the 5th instead of the 6th,
Oh, yeah.
or the 6th instead of the 5th, I think is what happened. Whatever it was, I have it written on the calendar incorrectly. So we have a few things for tomorrow, some straggler things, but it's not bad. And then if you look at the 10:30, those are all requests to lift Sarah stays, so it should be relatively quickly. It should move relatively quickly.
Yeah. Don't jinx us, Judge.
Good morning, Mr. Visconti.
Good morning.
Mr. Awa seems to have disappeared.
Yeah, he was in the breakout room with me, and I asked him to hold on for just a second because I wanted to take a look at a couple of emails that I'd received on this case, and all of a sudden he wasn't there, so I thought I would come out.
We'll give him a few minutes to reappear. My policy is 15 minutes after the scheduled start time, so as long as he's back by 9:15, I'll get the case called and get you on your way.
Thank you, Judge. Can I ask, is there anybody in the waiting room who might be for Belleville and Meadows? Perhaps Danny Partello?
There's not.
Thank you.
Mr. Awad's back. Did you need to go back into a breakout room with him?
I don't think so, Judge.
Okay.
Yeah, I don't think so.
This is 221208 LT. This is Belleville and Meadows versus Justin Awad. May I have your appearances, please?
Morning, Your Honor. Robert Visconti, P61756 for the plaintiff.
Good morning, Your Honor. My name is Justin Awad. I'm representing myself.
Thank you. Today's the day and time set for hearing on entry of default judgment and substitution of attorneys. The court asked the civil department to schedule this matter as we received a substitution of attorney that was only signed by Mr. Cox's office and not by Mr. Landau's office. Court sent notice to both law firms based on the fact that Mr. Visconti has appeared this morning. Order for substitution of attorney shall enter. Second issue is entry of default judgment, entry of judgment subsequent to the May 11, 2022 hearing. Mr. Visconti, the issue from this court's I don't know what the delay was in getting the judgment submitted. The court had asked for a copy of the ledger to be provided as the judgment was only to include rent. There would be no month-to-month fees and plaintiff would be entitled to regular court costs and statutory attorney fee. Mr. Awad was going to be allowed 28 days after entry of judgment to pay that amount or move. The court has received what's marked as a default judgment, did not receive a copy of the ledger as requested. Have you since provided that information to the court, or was your office even aware that that was the issue?
We were not aware that that was the issue, Your Honor. If that's the issue, we'd be happy to submit a revised order along with a ledger so that the court can have comfort with the numbers that are provided. You said the court will allow base rent only?
Yes, sir.
Okay. So yeah, we'd be happy to submit a new order that comports with the terms that the court has set forth this morning. The only thing I would ask is that, given that we're now into July, that the court revise the order or revise its ruling to allow for rent through the month of July.
Rent through the month of July. And Mr. Awad, have you made any payment towards the amount that's due and owing in this matter?
No, Belleville and Meadows still has not provided me with anything, to even a mechanism to pay. I don't get a bill. I don't have access to the portal. I have nothing. The only thing that they have ever dropped off is this huge amount of $15,000 that's owed.
And again, Your Honor, this is all news to our office coming in. Certainly, again, we can provide if Mr. Awad provides provides me with his email address, when we submit the order in the ledger, we can certainly CC him so that he sees what's being provided.
Absolutely. Mr. Visconti, if your office would provide a judgment copy of the ledger with the accurate numbers, and as we're more than 6 weeks past the date that the judgment should have been submitted, the court will amend its prior ruling. Mr. Awad will have 10 days to pay or move, which is statutorily allowed. Anything else, Mr. Visconti?
I just want to be clear, Your Honor, that I do the calculation in a manner that the court is comfortable with. So you said that, no month-to-month fee, correct?
Correct.
What if there's water and sewer that's regularly billed through I don't know, I haven't seen the ledger. I'm just thinking of the things that are typically included: water and sewer, site tax, things like that. Would the court permit that? And what is the court's position on late fees?
Absolutely, as to all of the utilities, sewage fees, the late fees. The court would allow.
Okay. So just take the month-to-month fees out, correct?
Correct.
Okay. We will submit that order then, Your Honor.
Anything else, Mr. Awad?
No, Your Honor. Thank you.
Could Mr.
Thank you,
Awad
Mr.
provide me with with his email address so that I can CC him, please?
It's farmerawad@gmail.com.
Farmer Awad.
Yep.
At Gmail.
Yep.
Okay, I'll be sure to CC you. Thank you, sir.
Thank you.
Thank you
Okay.
so much. You both have a wonderful day.
You
Thank
as
you,
well.
too.
Thank you.
Thank you. Mr. Gray.
All right, there we go. Yes, Your Honor.
This is 222183GC. This is Resurgent Receivables versus Smith. May I have your appearance, please?
Yes, Your Honor. Gavin Gray, P79819 for Resurgent Receivables.
Mr. Gray, today's the day and time set for the first pretrial on this matter. Matter scheduled at 9 o'clock. It's 9:14 by this court's clock. Court does not see that the defendant Smith has appeared. The court has not received any notice from downstairs that they have attempted to check in or use the court's Zoom room based on the defendant's failure to appear this morning. Sir, how would you like to proceed?
I would like to proceed with a with a default judgment.
Principal amount that's due and owing, sir?
So we have the principal amount at $1,658.65. I'd like to make a note, Your Honor, that we had sent a consent judgment out to the defendant and we never received it back. We have since received a payment of $93 on the account.
So the $1,658.65 is no longer accurate?
Now we'd have to deduct the $93 for sure.
Submit a default judgment to the court that shows the principal plus the court cost, please. You can submit that by email. The court will sign it and get it back out to you.
Okay, thank you, Your Honor. I appreciate it.
Anything else, Mr. Gray?
No, I don't believe so, Your Honor.
Thank you much, sir. Have a good day.
Thank you. You too. Bye now.
Good morning, Mr. Klein.
Good morning, Your Honor.
What are you here for, sir?
It's Mimic versus Parks.
I'm sorry?
Mimic Insurance versus, Alan Franklin. I had the wrong defendant.
Which? I don't see that on my docket sheet. Are you sure you're in the right courtroom?
34th District Court.
There are 3 judges and we're all on the bench this morning.
Okay.
Do you have the case?
This is the order I received with these ID numbers in it.
Do you have the case number, sir?
I do. The case number is 2215550GC.
That's with Judge Green, sir. Her ID
Okay.
number is 933 057 8570. I know the notice says something else, but it should actually be with Judge Green.
Okay, thank you, Your Honor.
Thank you. Mary Ann,
Yes.
I'm looking at this. Mr. Klein's notice would have said LMM Zoom, and it's actually with Judge Green. Would you give Michelle a call and make sure she has that file for me, please?
Michelle is not here.
Oh. Who's doing her docket?
I don't know the answer to that question. It
Okay.
might, yeah, I don't know if Heather is doing it or not, or Judge Green's doing it on her own.
Thank you.
Yep.
Have you been in contact with Mr. Beck's office?
We have been, there was a default judgment entered. We agreed to set it aside and we were going to speak. And since that time, we have not. Now, I did look at the order and it is scheduled for 9:15, but it said to appear 15 minutes early if we were going to appear via Zoom, which I did. So I'm happy to wait around till at least 9:30.
Okay.
And I don't want to take a default anyways against him, so.
Oh, I understand. It's just because he's not here, he's a little tardy. I didn't know if you wanted to.
Yeah,
start
I'll give him a
giving his
call.
Office a call.
Yep,
Okay,
that's what I'll
I'm not
do.
going first, so whenever you all, if he comes on, Mary Ann will put you in a breakout room. And you
Okay.
all can chat.
Sounds good.
Okay. Thanks.
Hello?
Hello?
Hi, I just want to let you know I did speak to Mr. Beck's assistant. He's in another Zoom call trying to get off. So I told him I'd sit around and wait for him.
Okay. Thank you for that update.
No problem.
Marianne, at 11 o'clock,
Yep.
there is 214814 GC Goddard versus Burrell. We have a conditional dismissal.
Thank you.
Taylor said she would call them and let them know not to appear. Mr. Werber, did you want to continue to wait for him, or did Mr. Beck give you any idea how long he would be where he was?
Your Honor, I was just about to come back on. I said I would wait till 9:45. It's 9:45 now. Like I said, I do not want to issue a default. I will certainly try to get in touch with Mr. Beck, see if we can resolve it. If not, I plan on filing a motion for summary.
This is 214658GC. This is credit acceptance versus Alonzo Tagger. This matter was scheduled for 9:15. It's now 9:45 a.m. by the court's clock. Mr. Werber, you've indicated you've been in contact with Mr. Beck's office, but neither he nor his client have appeared this morning.
That is correct. Jeff Werber, P67124 on behalf of the plaintiff. I spoke to Mr. Beck's assistant. Apparently he's on another Zoom hearing. I did inform her I would wait until 9:45. I do have another hearing in 36th District Court that's about to start. But I do not want to default Mr. Beck. I will try my best to get a hold of him and resolve this. If not, I plan on filing a motion for summary.
In as much as you do not want to request entry of default judgment, you want me to adjourn this to our next civil date, which is August 2nd?
Yeah, that's great.
Okay. I'll adjourn to August 2nd at 9 a.m.
Sounds
Anything else,
perfect.
Mr. Werber?
No, thanks for your time this morning, Your Honor. Have a great day.
Thank you for your patience, sir. Have a
Of
good day.
course. You too.
Thank you.
Good morning, Mr. Morton. How are you?
Good morning. I'm, moving along.
How's your baby?
She is doing wonderful. She enjoyed her first 4th of July parade yesterday. Yeah, I remember what day it was.
Is she what, 5 months?
She is now 7 months old. So yes, and she's learning how to swim too. So we had her, she takes swim lessons with my wife, and we had her in the pool yesterday. She's learning to kick and things like that and get water close to her face, you know, that kind of stuff.
Oh my gosh, is that the sweetest thing ever?
She is, yeah, it's funny. It's a strong comparison. In the pool, we had that little one, and then we had a 2.5-year-old who literally just wanted to be thrown up and in the air and then just splash in the water, and then to have that done for like hours straight.
You get your workout.
Absolutely.
I'll let the judge know you're here.
Absolutely.
Good morning, Mr. Beck.
Good morning, Your Honor. I'm very, very sorry.
No, this is Mary Ann. The judge, just stepped off the bench for a minute. That case has been adjourned to August 2nd at 9 o'clock.
August 2nd?
Yes,
Okay, at 9 o'clock?
correct.
Okay, well, thank you very much. I apologize to the judge, please.
Oh, yeah, she was aware. Also, she said if you want to get a hold of Mr. Werber and get back on, I know he had another hearing at the 36th, but if you want to do that, she said she wouldn't mind.
Okay, no, it's fine. So it's August the 2nd at 9 o'clock?
That's correct.
Very well. Have a very pleasant day. Thank you very much.
Okay, bye-bye.
Bye-bye.
Mr. Morton?
Yes, I see the defendant has appeared. If you want to put us into a breakout room, we can certainly speak.
Read my mind. Thank you.
Marion, if you could also put, was it Miss Nichols in the breakout room, that'd be wonderful.
Sure.
So what we'll do is the 10 o'clock and then I'll take a walk. I think.
It's Murphy's Law, right?
No, I mean, I'm serious. We have a break and I'll take a walk, stretch my legs. So that lady who did the picture that's up in my office,
Yeah.
she does these massive mixed media collages. She had an exhibit out in East Hampton and she sold the installation piece.
Oh, you're kidding me.
No,
Wow.
I ran into her sister on Sunday and I told her, I said, it's gonna be impossible to get any of her work now.
Oh, yeah. But isn't
So
that
this
cool?
moment is just, she's just so talented. I still would like a big installation piece. I can't imagine, I don't know where I will put it now, but. Oh. This is 221729 LT. This is GI versus Mohammed Aon. May I have your appearances, please?
Your Honor, for the record, Attorney Ian Morton of Pallets Law on behalf of a GNI Harbor Club.
Your Honor, Mohammed Aoun, the defendants, and I want to thank the court for rescinding the default based on the fact that the landlord did not serve me the paperwork based on the Michigan
Sir?
law 2 point. Yes, ma'am.
Sir,
Yes, ma'am.
we're not there yet.
Okay.
We're not there yet.
Okay.
The court has not rescinded the default judgment. The parties did have the opportunity to go into the breakout room this morning and discuss this case.
Yes, ma'am.
Any resolution, Mr. Morton?
No, Your Honor, the parties were not able to reach a resolution.
Thank you. Sir, you are accurate in as much as today is the day and time set for hearing on your motion to set aside the default judgment. Plaintiff's office has filed a response. Would you please present your motion, sir?
Yes, ma'am. My motion is based on the Michigan law 2.105. I never received any in-person or registered mail for the hearing on May 4th, before the hearing on May 4th. I didn't receive anything. And to reference, last August, I had a hearing and they did indeed serve me correctly. And I did appear on time. Now, I am still under the protection of the CERA law. My case is 299233. They are making payments, but they are backed up on those payments for the rent. Mr. Morton, they did make a $3,000 payment, correct? Recently?
I was going to let you finish making your argument because this isn't necessarily your opportunity to depose me. So please move forward, Mr. Mohammed, and make your argument.
I will make the argument. So under the Michigan law 2.105, they did not serve me in person. They did not serve me in registered mail. I did not receive the summons for the May 4th hearing.
So, sir, you're saying that court officer Rocco Rossi did not post the summons and complaint for this non-payment of rent case at apartment 37 on April 18, 2022?
I did not see it on my door. No, ma'am. I never
I
received.
didn't see it and it wasn't posted or not the same thing.
Yeah, well, I didn't. It was not posted on my door because obviously.
Are you the only person in that apartment unit, sir?
I'm the only person inside the unit, but there's 6 or 7 people that live in the building.
Anything else, sir?
No, ma'am.
Your response, Mr. Morton?
Thank you, Your Honor. I mean, the court has in front of it the proof of service that was completed by the court officer on 4/18. Further beyond that, the default wasn't taken on the next hearing date, which was 5/4. It was taken on the following hearing date, which means notice would have also been mailed out to appear, preferably in person, as this court's normal procedure is, at the next hearing date, which was on, May 12th. Was then at that point a default judgment was taken, which the court would have then also sent out to Mr. Mohammed as well. So he would have received service would receive the copy of the judgment at that point. Was it after that point? Was it in July? Was it Mr. Mohammed would have received posting based on the court record? He would have received a copy of the second hearing notice. He would have received a copy of the judgment, and it is not to the point when we are now, which would have been over a month, I believe, from approximately a month when the judgment was entered, to be able to file this motion, which we believe is beyond the time period. Further, he has failed to put forward a meritorious defense to the case. We did submit an order of eviction recently, which we did account for the $3,000 payment that was made, and that was accounted for in the order of eviction that was submitted to the court. However, was it at that time, because the judgment was entered, was it in the amount of $6,604? That still is far shy of paying the entire balance off. And at this point, the total balance due and owing has continued to increase because there's only that singular payment that was made at the time of hearing. I mean, sorry, that singular payment that's been made. Based on that, Your Honor, we would ask that his motion be denied and that the judgment or writ be allowed to proceed, unless there's some sort of proof that there is a active, SIRA application? I mean,
Yes.
One moment, Mr. Mohammed, please. Your Honor, then the court could take that into consideration, of course. However, that $3,000 payment that was received was applied and was accounted for when we moved forward to request the order of eviction.
Thank you. Any response, sir?
Yes, ma'am. I do have a response, 2 responses. Number one, as far as the SIRA goes, I do have an active case. It's active case 299233. They did cooperate, and they did make a $3,000 payment during the time that this was going on. They also told me today, July 5th, to absolutely appear, and they are working on getting the rest of the money to the landlord as fast as they possibly can. They're backed up. As far as the service, I want to be clear. Michigan state law is very clear, 2.105. It doesn't say post on the door, or it doesn't say, it says a serve in person or registered mail. That's what the law says. And, I'm not trying to avoid the law. I'm just going based on Michigan state law. Mr. Morin wants to make it a very minimal type of thing, but it's very serious as far as service goes. I know that you take it very seriously, Your Honor. And as far as the balance, he says it's increasing. It's actually decreased. They paid 50% of it, and now it's obviously going to be somewhere around $4,250. Am I correct, Mr. Moore?
I will answer that one. I can tell that the balance due and owing as of today's date, since we're in the month of July, is $5,264.
Okay, and I'm cooperating as much as I can, doing everything that SIRA is asking me to do. I can have them tell you how much I've cooperated with them. I mean, they're just backed up, unfortunately. The process for getting from the recertification to the payment has become now 6 months, and that's basically it as far as my response, ma'am.
Okay, sir, so the $3,060 that was paid out was in response to SARA application 299223?
299233, yes.
233. And have you made an application for recertification?
Yes, and that's actually in process, but the process takes 6 months sometimes.
When did you reapply?
Well, first, I had been approved protection for 15 months as long as I recertified. So I recertified in January, and then I had recertified in April. So they paid the January, but still have not paid the April through June. And then obviously there was another recertification from May 30th to July 30th. So it's a quarterly type of thing. The SIRA works in a quarterly type of thing. But they're so far back.
Mr. Morton, do you have any information about a recertification subsequent to the $3,060 payment?
No, Your Honor, I do not have any current information. I don't have some of the same access that Lakeshore Legal Aid does in regards to some of the systems. I know that, though, Your Honor, as this court's probably relatively aware, that the recertification the maximum it'll likely pay is around $3,000, which would potentially cure the judgment about what would not cure the current past due balance amount.
Your Honor, I want to be.
Sir,
yes.
I'm sorry. Go ahead.
Oh yeah, I was going to say there is a recertification application in there, and I could show it to you if you'd like today. I could show you evidence of it if you'd like to see it. So, like I said, the landlord has really turned in their activity as far as SIRA goes. I have it. Would you like to see it? I can pull it up right now on my phone and show it to the court that there's a recertification.
If you want, sir, if you want to, the court will see it. But here's the problem. Let's start with your motion. You have a motion to set aside default judgment that indicates that you weren't served. This court reviewed the file, and there is a signed proof of service in the file from this court's officer, Mr. Rocco Rossi, that says he posted it at the property, which is allowed by court rule, tacking at the property for this
Yeah.
non-payment of rent case. Hold
Yeah.
on.
Okay.
For this non-payment of rent case, your original court date would have been May the 4th, 2022, when you did not appear. A court clerk in this building would have mailed a notice to you on May 5th directing you to appear in person on May 11th. When your case was called on May 11th, the case was called by me, you failed to appear at 10/21. The court entered a default judgment based on your failure to appear on May 11th. And then the court you did not present yourself to the court after entry of judgment on May the 12th. You did not present yourself to the court until June the 6th. So well after the May 5th notice that was mailed to you and the default judgment that would have been mailed to you on May the 13th, 2022. Based on those two notice issues, this court will deny your motion
Ma'am,
to set
ma'am,
aside the default.
I
Hold
have
on,
one
nope,
question. I
nope,
have one
nope,
question. for you.
nope.
I can't ask one question?
When I
Just one.
say, you can ask me a question, but don't interrupt me while I'm talking.
Okay.
I didn't interrupt you.
You denied me before I asked the question, though. It's very important, Miss Martin. Would you allow me, please? I'm sorry for interrupting.
No, you're not, but please
I am.
proceed with your question.
I am sorry for interrupting you. I really am. But I'm so upset about you because the officer clearly stated that he posted it on a door. He did not personally give it to me or registered mail. How's that a process? It's not. Michigan state law says he has to give it to me in person or he has to give it to me by registered mail. We're skipping that fact. That's a very big fact, Your Honor.
Hold on. We're not skipping any facts, sir. He is allowed to attach at the dwelling. That is provided by court rule. And if you had not interrupted me, what you would have heard me say is, this court is denying your motion to set aside default judgment. If you had appeared on May 11th with proof that you had a SARA application pending, the court would have stayed the matter for 45 days. Period. You didn't appear. The court mailed out a copy of the default judgment to you, and you did not take any additional action for almost a month. This court is willing to see if you have an active SARA application pending. And if you had not interrupted me, we would have been there 2 or 3 minutes sooner. If you have proof that you have a SARA application pending right now, even if it's recertification, the court will not enter the application for the order of eviction. Do you have proof that you have a SARA application actively pending right now?
Yes, ma'am, I do. I'm pulling it up right now. I again apologize.
And sir, are you not making any payment, or have you not discussed making any payment towards the balance of your landlord?
Your Honor, the SERA program has told me that they were going to make all payments, not to worry. If I have court to refer to the case, I got, I know you hear a lot of stories, but I got COVID twice. Once after I was vaccinated. I've been in and out of jobs, so that's why I'm actually, still on the SERA. And they're telling me at SERA not to get off of it until I'm absolutely sure that I can do all of this. And here's my active case right here. 299. I don't know if you can see it in the camera. 299-233.
I can't see it.
How am I supposed to give it to you then? There's the camera.
Is it a different number than the 299-233 you listed on your motion to set aside default judgment?
It is 299-233 -recert-2. So it's 299-233 will get you to the case, and this particular one is a recert number 2. And this was given to the landlord. The landlord should know about this, and they are denying it. And SERA is actually told me when you go to court, if you get any paperwork, to send it to CIRA because they're gonna follow the federal law right now and they're gonna pursue it.
Mr. Morton, do you have any information about this?
Your Honor, I can check the Sierra status website right now, which has less information normally than what legal aid has access to. If I can get his date of birth, which normally my client would have, but I don't have it, I don't have the application information in front of me. If you'd like, Mr. Muhammad, if you can give that to me, if you want to put it into a breakout room, so it's not being recorded.
No, I would like it to be recorded because
wait, Mr. Muhammad.
Sir,
A moment.
you probably don't want you probably want as little personal information out there as possible. You
I know,
can either
but
go
Your
into a
Honor-
breakout room and give it to Mr. Morton, or you can chat it only to Mr. Morton.
Okay, yes, but I want to make it clear that he's not communicating with his landlord, obviously, because the landlord should know about this because they receive direct correspondence from CIRA. He should know that they have a CIRA application.
You again, sir, are missing the point and answering questions that haven't been asked. Mr. Morton has said that he will look into it right now if you will
Okay.
provide your date of birth. If you want to do it on this hearing that's being streamed on YouTube, you are more than welcome to. I'm asking you to put it in the chat or go back into a breakout room with him. One of those three ways, however you want to do it, is how we'll do it right now.
I'll go into a breakout room with him, but he's already denied that there's a CIRA application out there. He's already said there's no CIRA application out there, but let's go into a breakout room. I'll give you my birthday.
Thank you.
Good morning, Ms. Owens.
No.
Good morning, sir.
Good morning.
How are you?
I'm doing well. Rested over the weekend. I hope you did too, Your Honor.
You are a little early, and I have not seen Davis yet.
Yep,
Fine.
she's here.
Oh, here she is. Thank you. Do you need to go into a breakout room?
I'd appreciate that. Yes, please, Your Honor.
Okay, Mary, I'll get you moved.
Thank you so much.
You're welcome. Ms. Owens?
Yes.
The attorney for your landlord is here. We'll get you moved into a breakout room to discuss your case with them, okay?
Okay,
I'm not sure what the background noise is, but you need to get somewhere quiet before your case is called, okay?
okay.
Thank you. I don't know how she does that, Mary Ann.
What's that?
Rachel.
Oh my gosh, I know. The little peachy colored ones, I don't know, like, they look like coral, but they were so brilliant. And I didn't touch them, but they look really like they would be very soft. That's cool. And I've never seen a vase like that.
It is, it's super cute. And there was nothing in that corner, which always just looks so barren.
Well,
I try
that,
to keep stuff over there, but
yeah, that's doing the trick.
Lady Justice just looks so lonely sometimes. Mr. Morton, were you able to get the information that you needed to verify?
As I spoke to Mr. Muhammad, I had difficulty logging onto the website that I was able to, but I did see Mr. Muhammad's screen. I did see that he resubmitted on May 27th for the second recertification. Based on that, Your Honor, we would not have an objection if the court wanted to reset this matter till the end of the month, which would be 45 days from the entry of the judgment, which would give them an opportunity to have a stay to be able to get those funds. We had some other conversations, which he and I are not on the same page, but that's the way it goes. But so if the court's open to it, we're open to allowing him until the end of the month to be able to try to obtain those funds.
Your response, sir?
Ma'am, I want to bring up those issues that me and him didn't have. So he couldn't find it. I found it for him. And then he started spewing out some stuff about how SERA no longer exists. All lawyers and judges have been are aware of this, and just more aggressive stuff from the landlord, you know. So I'm just letting you know, Your Honor. He's giggling about it. I'm not laughing about it. It's not funny to me.
Your Honor, if I may, Your Honor.
I'm being told like stuff that's not true by the plaintiff, and I'm supposed to believe it.
If I may, Your Honor.
If you feel like you must, sir.
Very brief. I advised him that the SERA process was no longer accepting applications or research.
That's not what you said,
Sir.
It's recorded. That's not what you said. You said that the SERA program's over, that lawyers and judges have been. I'm the one that corrected you and told you.
Let me stop. I will interrupt both of you and stop both of you. This court has received the directive that that Administrative Order 2020-17 remains in place. Mr. Morton suggested to continue this matter for 30 days. This court will not do that. This court will actually stay these proceedings, not enter the previously submitted previously submitted application for order of eviction. Mr. Aon, what'll happen is 45, you'll get a copy of that stay. If your landlord does not receive payment within that 45 days, they'll make a petition to the court or sign a request to the court to lift the stay and schedule this matter for hearing. The hearing would be on the order of eviction.
Ma'am, I'm a little confused
Sir.
here. Okay, so I
You're
got to
confused
receive.
by which part?
Yeah, the dates here. So they have to receive payment by what date?
There is, the administrative order is for a 30-day stay. The stay that this court sends out says 45 days. So if 45 days from today's date, your landlord has not received payment in full, or they've received information that you are not eligible for additional funds under the recertification, they can sign that same stay, send it back to the court and ask the court to schedule it for hearing. If the court schedules it for hearing, it will be to enter the order for eviction that plaintiff's office filed with this court on June the 7th. And the only defense to the order of eviction would be payment in full.
By SERA, correct? Or by me?
By somebody, by
Okay.
Sarah or by you.
So 45 days from July 5th, 2022.
Yes, sir.
Okay, so
I'm sure over Mr. Morton's objections.
Correct, Your Honor, but I understand the court's decision and its ruling. Actually, I would ask for one clarification, Your Honor, if I may.
Sir,
Very brief. Is that the balance from the judgment entry in May, or is that the balance that's due as of today's date?
Mr. Morton, that's the tricky question. Because you can only collect on that judgment amount, correct?
Correct, Ron. The judgment amount that was entered was for $6,064. I know that we submitted the order of eviction, which the court is not entering today, of receipt of $3,060. So that would leave a balance due on that judgment entry of about $3,004. My math is correct, based on those two numbers. So I mean, I understand the court's decision either way, if it's only based off of the judgment entry, or if it's based off of, or we could just, include in our request for a new hearing and argue it at that point.
Would you argue it at that point if necessary?
Absolutely, Your Honor, understood.
Anything else?
No, Your Honor.
I didn't understand that last part, Your Honor. He wants to set a new hearing to argue.
He doesn't want to say anything. The court is staying the proceeding, sir. The only way that the price will be back is if your landlord is not paid under the SARA program. And if that were to happen, the landlord would have to send notice to the court that they want the stay lifted. The court would send you another notice to appear that the plaintiff has requested that the stay be lifted and a hearing be scheduled on the order for eviction.
So the amount is $3,004 in 45 days. What's the amount in 45 days?
That is the amount of the judgment balance. The plaintiff's office is indicating that they may make an argument for the months of rent that have come due subsequent to today's hearing. We are not discussing that today. That's their argument if they need a hearing in the future.
Okay, so if they need a hearing between now and the 45 days, I have to understand this, Your Honor. It's like being
No,
spoken.
sir. See, no, because the court can't give you legal advice. I'm repeating in different language what Mr. Morton has said, sir. But this
I'm
hearing
just
is
asking
concluded.
questions, though. I'm asking
You're
questions.
not
ma'am.
just asking questions, sir. You're not just asking questions, but it's okay.
Okay,
The
so
court has denied your motion. There is nothing else before this court this morning. There are other cases that need to be called. This matter is concluded. You'll get a
So
copy of the stay in the mail from the court clerk, sir. Have a good day.
have a good day, ma'am. Thank you for.
Thank you. Are we ready on Henderson?
Yes, I'm here.
221347 LT Parks at Belleville versus Gregory Henderson and Starlisa Henderson.
Ryan Woodjick, P 84535 on behalf of the plaintiff.
Mr. Henderson, state your name for the record, please, sir.
Gregory Henderson.
Mr. Henderson, are we expecting Ms. Henderson?
No.
Today is the day and time set for hearing on plaintiff's request to lift the Sarah stay that went in place back on April 27, 2022. 69 days have passed since entry of that Sarah stay. Has plaintiff received payment?
Yes, Your Honor, we did receive a Sarah recertification that did not cover the balance in full. I did have a chance to speak with Mr. Henderson. He's agreed to consent to a judgment in which we'd give him a little more time to catch up on his balance. He currently owes 2 months' rent, give or take.
How much is owed in rent, sir?
At this point in time, we're showing rent to retain as $2,323.83. And we also have
Court cost total?
$164 for the total due and owing of $2,487.83.
You indicated you were allowing him a little more time to pay. How much is a little more time, sir?
That is correct, Your Honor. We agreed to allowing Mr. Henderson until July 21st of 2022 to pay the amount owed.
Mr. Henderson, were you able to hear the attorney just now?
Yes.
And sir, that is what you wish to agree to, that you will pay $2,487.83 on or before July 21st, 2022?
Yes.
Primarily, sir, in as much as more than 30 days have passed since entry of the stay and the plaintiff has not received payment in full or indication that you're not eligible for Sarah funds, this court is required to lift the stay. Stay is now lifted. The parties will submit a consent judgment with the terms just placed on the record. Is Mr. Henderson signing, or do you have his authorization to sign the consent judgment, sir?
No, Your Honor, I've received his consent to sign his name on this judgment, and I will email that to the court right after this hearing.
Thank you. Anything else, Mr. Henderson?
No, that's it.
Mr. Henderson, just so we're on the same page, did the attorney explain to you that because your landlord is represented by an attorney and you are not, that the judgment will not be final for 3 days?
Yes.
Okay. Thank you. That concludes this hearing. Have a good day.
Thank you, sir.
Thank you. You as well.
Thank you. Good morning, Mr. Landau.
Good morning, Your Honor. I apologize about my technical difficulties. I don't know what's going on with my computer, but I'm logged in on my phone now.
Okay. Give me 1 second to get the file out. This is 22. Oh, not quite yet. Have we seen Ms. Langer this morning?
No, ma'am.
Mr. Landau, we're not quite at the default time. I was looking for your tenant. I don't see her. My standard is 15 minutes after the schedule. Your schedule at 10:30. See if Julie Langer appears by 10:45, okay?
Very good.
Thank you. This is 221511 LT. This is MIMG versus Davis. May I have your appearances, please?
Yes, John Burngrant for the plaintiff landlord, Gateway Townhomes.
Hi, Deja Davis.
Ms. Davis, turn your video on for me, please, ma'am.
Sorry. I'm sorry. I gotta lay my baby down.
Today is the day and time set for hearing on the plaintiff's request to lift the Sarah stay. That stay has been in place since April the 27th, 2022. 69 days have passed since entry of the stay. Has your client received payment in full, sir?
My client has not, I did talk to Ms. Davis, and we do have a consent judgment, which I can place on the
The
record.
terms, well, in as much as your client has not received payment in full, the Sarah stay is lifted. What are the terms of the consent judgment, sir?
Your Honor, the balance owing in rent is $104, court costs of $167, for a total redemption figure of $271 to be paid by no later than July 15, 2022. Otherwise, Ms. Davis has agreed to move out by that date. I've also explained that she has 3 days in which to come back to court to ask that the judgment not be entered.
I'm sorry, sir. The only thing I could not hear was her pay by date.
Oh, I'm sorry, July 15, Friday, July 15, 2022.
Thank you, ma'am. Were you able to hear the attorney just now?
Yes.
And that is what you wish to agree to, that $104 in rent is owing $167 in court costs for a total of $271?
Yes.
And he further explained to you that you would have the ability to come back within 3 days of entry of the judgment if it did not reflect what you agreed to?
Yes.
And are you signing this judgment, or are you authorized the attorney to sign your name to it?
I'm authorizing my attorney to sign my name.
Landlord's attorney, is that correct, Ms. Davis?
Yes.
Okay.
Thank you. Upon receipt of a consent judgment with the terms just placed on the record, the court will sign the same and mail it to the parties. Anything else on behalf of the landlord?
Nothing further, Your Honor. I do appreciate it. Have a good day.
Anything else, Ms. Davis?
No, thank you.
Ma'am, have a wonderful day.
You too.
Thank you. I'm not going far, Mary Ann.
Okay.
That's what happened, Marianne. I kept coming out and didn't have water. And we had not seen Mr. Katz, have we?
Yep, he's here.
Is he? Oh,
Yeah, he's been here.
I see him now. I guess that was wishful thinking, but is Miss Owens coming out?
Yes, she is, Your Honor.
There we are. 221751 LT. This is GI versus Owens. May I have your appearances, please?
Your Honor, for the record, Attorney Ian Morton of Pallets Law on behalf of GNI.
Susie Owens.
Good morning. Today is the day and time set for hearing on plans requested with the Sarah State that's now been in place since May 4th, 2022. 62 days have passed. Mr. Morton, has your client received payment from the
No,
Sarah
ma'am.
program for the past due rent?
No, they have not, and the parties have spoken, and we do have a proposed resolution.
And that would be, sir?
Your Honor, was it after speaking with Ms. Owens, we've agreed to enter into a consent judgment with July 29th as the payment date. Further, was that there'd be a term in there that would say no writ may be ordered without a hearing date. Further, the rents retained are $4,835.02, core cost of $167, for a total of $5,002.02. Was it, and both the parties have agreed. I've advised Ms. Owens of her rights under MCR 4.201, which is the 3-day time period, Ms. Owens, we talked about. And then in addition to that, was that she did give me permission to sign her name to this consent judgment.
Ms. Owens, were you able to hear everything that Mr. Morton just said?
Yes, Your Honor.
And you wish to agree to entry of the consent judgment showing that $4,835.02 in rent is due and owing, $167 in cost, for a total of $5,002.02?
Yes,
You further understand that payment in that amount will be made by July 29, 2022?
yes,
And that even if that payment was not made to the plaintiff by July the 29th, that there would be no writ in this matter without a hearing?
correct. Yes,
And Mr. Morton explained to you the 3-day period by which you could come to the court and if,
yes,
and before the
Yes.
judgment will be final. Okay. And you authorize him to sign the consent judgment on your behalf.
yes, Your Honor.
Upon receipt of that signed consent judgment from plaintiff's office, the court will enter the same and you'll get a copy in the mail. Anything else, Mr. Morton?
No, Your Honor.
Anything else, Ms. Owens?
No, Your Honor.
Good luck, Ms. Owens. Have a good day.
Thank you. You as well.
Thank you. This is 220846 LT. This is Barrington Romulus versus Douglas Ellis. Nope, okay. This is 221297 LT. This is GI&I versus Brandon Jeffries and Jennifer Thompson.
Your Honor, for the record, Attorney Ian Morton of Pallets Law on behalf of GNI, just for the record, at least one time, P67892.
Thank you. Today is the day and time set for hearing on plaintiff's request to lift the Sarah State that's been in place since May the 4th, 2022. 62 days have passed. Matter scheduled for 10:30 is now 10:48 a.m. by this court's clock. Jeffries or Thompson? Defendants having failed to appear, Mr. Morton, how do you wish to proceed?
Your Honor, at this time, first for the record, the payment for the Sarah funds has not been received. They did make one payment of $909 in the month of May, which was applied, but as of today's date, rents retained are $7,910, core cost of $189, for a total of $8,099.00. We would ask a default judgment for possession only be entered against these parties.
The Sarah State is lifted based on the defendant's failure to appear this morning. Default judgment shall enter as prayed by plaintiff with $7,910 due in rent, $189 in court costs, for a total of $8,099. Plaintiff's office to submit that default judgment. This is 221731 LT. This is GNI versus Kiera Carpenter. Mr. Morton, your appearance is noted for the record. This case similarly is scheduled for hearing on plans request to lift the Sarah stay that went in place back on May the 4th, 2022. 62 days have passed since entry of that Sarah stay. Mr. Morton, has your client received payment in full?
No, they have not, Your Honor. Since the entry of the Sarah stay, they have received a payment totaling $750. However, we would move forward to seek entry of a default judgment for possession. Rents retained are $3,036.00. Court costs of $167 for a total of $3,203.00.
Inasmuch as this matter was scheduled at 10:30, it's now 10:50 by the court's clock. Defendant having failed to appear, the Sarah stay is lifted. Default judgment shall enter in favor of plaintiff and against defendant with rent to retain of $3,036, $167 in court costs for a total of $3,203. Plaintiff's office to submit that default judgment. Good morning, Ms. Robinson.
Good morning.
Have you had the opportunity to speak to Mr. Morton or Ms. Nichols?
No.
Ma'am, I'm going to have you go into a breakout room to discuss your case with the attorney for your landlord. Once you come back out, I will call the case and get you on your way, okay?
Okay.
Thank you.
Your Honor, if you'd like, are you going to assign her? Should I assign her to a room, Your Honor?
Go ahead, you're co-host.
Okay, thank you.
Mr. Katz, this is a recall of 220846 LT. This is Barrington versus Douglas.
Versus Douglas. I don't have that one, Your Honor.
Are you still Sydney P. Katz?
Sometimes I wish I weren't, but yes, I still am.
Oh, hush.
Douglas, oh, you know what? I sent it. Is this Douglas Ellis?
Yes.
Yeah, we sent in a dismissal on this one already. But if need be, I could send a new one.
It has not reached the file. I'll make a notation. We were a little short-staffed in the civil department last week, so it might be downstairs. I have made an indication in the file that it's to be dismissed, so hopefully your paperwork will reach the file. This is 221403 LT. This is Barrington Romulus versus Goodman. Mr. Katz, your appearance is noted for the file. Today is the day and time set for hearing on plans request to lift the Sarah stay that entered back on April the 27th, 2022. 69 days have passed since entry of that Sarah stay. Matter was scheduled at 10:30. It's now 10:52 a.m. by the court's clock. Defendant has failed to appear. What's the status of this matter, sir?
Your Honor, my client did receive some Sarah funds, but it never brought the account down to zero. Your Honor, as of today, there's currently a balance of $1,506 of past due rent, $160 of costs for a total of $1,666. Since we are past the Sarah stay on this matter, I am requesting a default judgment in that amount with the writ to be issued after July the 16th.
Thank you. Based on the defendant's failure to appear this morning, the previously entered Sarah stay is lifted. Default judgment shall enter in favor of plaintiff and against defendant with rent to retain of $1,506, $160 in court costs for a total of $1,666. Plaintiff's office to submit that default judgment. Good morning, Ms. Clark.
Good morning.
How are you, ma'am?
I'm okay, thanks. How are you?
I'm wonderful. Who is your landlord, please?
It's Pine Woods Village property.
That's one of mine, Your
Ma'am,
Honor.
I do not believe. Pine Woods?
Correct.
Oh, at
Your Honor,
10,
that's
at
an
11:30.
11:30.
Oh,
It's
11:30.
11:30, ma'am. You're
Okay.
You're a little bit early. If you want to hang out, that's great. Let me just get through the 10:30 docket, okay?
Thank you.
And then I'll put you in to talk to Mr. Katz, okay?
Thank you.
Thank you. Oh, Mr. Katz, is that it?
Yeah, that's my only other one. If we could hear Ms. Clark, that would be great. If I could talk to her.
You
and
want to go in and have a chat with her, and if you're ready before any of the other 10:30s, I'm happy to call it.
Perfect. Thank you, Your Honor.
Mr. Landau. Good morning, Van Buren.
Good morning.
I don't have a file yet.
Okay.
Take your hands out of your pockets, please.
Yes, sir.
As soon as I get the file, I'll let you know and get you made it up. Was there a request for MIDC?
No.
Okay, as soon as I get the file, I'll call the case and get proceeding on the arraignment, okay?
Okay.
Thank you. This is 221750 LT. This is GI versus Robinson. May I have your appearances, please?
Your Honor, for the record, Attorney Ian Morton of Palace Law on behalf of the plaintiff. I would like to clarify one thing, though. Miss Robinson this is a different Miss Robinson. She's here in a different case. We found that out when I started to speak with her.
Which case should it be, sir?
Miss Robinson, what was your case number again?
It was 2222622 LT.
Allison Robinson at 11 a.m. Okay.
Here we go.
With the different attorney's office. Miss Robinson, you are a little bit early. If you sit tight. Your case is scheduled at 11 o'clock. I have not seen anyone from that attorney's office yet. We'll get you called and get you on your way as soon as possible, okay?
Okay.
Thank you. Was that enough time with Clark?
Yes, Your Honor, we're going to actually ask for an adjournment.
This is 222489 LT. This is Pinewood Circle versus Desiree Clark. Your appearances, please.
Good morning, Your Honor. City Katz on behalf of the plaintiff.
Ms. Clark, state your name for me, ma'am.
Oh, I'm sorry, Desiree Clark.
Thank you. This matter was actually scheduled at 11:30 this morning. The parties have appeared. And Mr. Katz, you're indicating that the parties are requesting another adjournment of this case?
Yeah, Your Honor, it turns out that Ms. Clark does have a SARA number. I don't think she provided that last time. So she does plan on paying it. So we could do a 45-day stay at this point.
Based on the defendant's submission of an application for SARA funds, this matter is hereby stayed. Ms. Clark, the next thing you will receive is a copy of that stay. Will indicate that if within 45 days your landlord has not received payment in full, or they have not been notified that you're not eligible for funds, they may submit a request to the court to lift the stay and schedule the matter for hearing, okay?
Okay.
Any questions?
No.
Good luck to you, ma'am. Have a good afternoon.
Thank you so much. You do the same.
Thank you, Your Honor. And
Thank you.
I'm all set with you for today. Thank you.
Are you really?
I know it's
Have a
I know
good day,
it's
Miss-
disappointing, Your Honor. I could see the disappointment in your face.
Have a good day, Mr.
All
Katz.
right,
Good to
I'll
see
see
you.
Bye-bye.
I just saw somebody pop in from Mr. Levine's office. Did you put him in the breakout room that fast? Good
I'm here.
morning, sir.
Good morning.
Ms. Robinson is here. Do you need to speak with her?
Sure. I think it's
Marianne, I'll
fine.
get you moved into the breakout.
Thank you.
This is 221738 LT. This is GI versus Terrence Finch. Mr. Morton, the court notes your appearance for the record. Today is the day and time set for hearing on plaintiff's request to lift the SARA stay that's been in place since May the 4th, 2022. 69 days have passed since entry of that stay. Matter was scheduled for 10:30. It's now 10:59 a.m. by the court's clock. Defendant has failed to appear. How do you wish to proceed, sir?
Your Honor, at this time, we would ask a default judgment for possession be entered. No payments have been received since the issuance of the stay. Rents retained are $4,499.61. Court costs of $167, for a total of $4,666.61.
Thank you. Inasmuch as the defendant has failed to appear as directed by this court, the SARA stay is lifted. Default judgment shall enter in favor of plaintiff and against defendant with rent to retain of $4,499.61, $167 in court costs for a total judgment of $4,666.61. Plaintiff's office to submit that judgment for entry. This is 221472 LT. This is GI versus Denise Henry. Denise Henry. Today is the day and time set for hearing on plaintiff's request to lift the SARA stay in this matter. Mr. Morton, your appearance is noted for the file. The SARA stay entered back on May the 4th, 2022. 62 days have passed. This matter was scheduled for 10:30. It is now 11 a.m. by the court's clock. The defendant has failed to appear. How do you wish to proceed, Mr. Morton?
Your Honor, this tenant had been seeking assistance through ERAP. While my client has received some payments, independently of that, which were not unsubstantial, there's still a balance due and owing. So based on that, we would ask a default judgment for possession be entered. Rents retained as of today's date are $1,475.00. Court costs of $167 for a total of $1,642.00.
Based on the defendant's failure to appear as directed by this court, the previously entered stay is lifted. Default judgment shall enter in favor of plaintiff and against defendant with rent to retain possession of $1,475. There's $167 in court costs for a total judgment of $1,642. Plaintiff's office shall submit that default judgment for entry. This is 221749 LT. This is GI versus Taylor Roden. Taylor Roden, R-O-D-E-N. Mr. Morton, the court notes your appearance for the record. Today is the day and time set for hearing on plaintiff's request to lift the SARA stay that went in place back on May the 4th, 2022. 62 days have passed since entry of that stay. This matter was scheduled for 10:30 a.m. It's now 11:02 by this court's clock. Defendant has failed to appear. Mr. Morton, how do you wish to proceed?
Your Honor, at this time, we would ask a default judgment for possession be entered. The defendant has not made any payments since the entry of the SARA stay. Rents retained are $5,710.00. Court costs of $167 for a total of $5,877.00.
Based on the defendant's failure to appear as directed by this court this morning, the SARA stay is hereby lifted. The default judgment shall enter in favor of plaintiff and against defendant with rent to retain possession of $5,710. There's $167 in court costs for a total judgment of $5,877. Plaintiff's office to submit that judgment for entry. This is 220490FY. This is State of Michigan versus Raina James. State your name for the record, please.
I am Raina James.
Thank you. Today is the day and time set for your arraignment in this felony matter. This court has received the file with an indication that you choose not to have the court-appointed attorney assist you with your arraignment this morning. Is that accurate?
Yes, ma'am.
You intend to proceed on your own?
Yes.
You have an absolute right to be represented by an attorney inasmuch as this is a felony matter. There is a petition for court-appointed attorney attached to the front of your file. The court is signing that. You will be assigned an attorney going forward. The attorney will use the phone number that is listed on your petition to be in communication with you. The
Yes, ma'am.
underlying felony complaint provides count one. It alleges that on July 3rd, 2022 in Van Buren Township that you committed the following acts. Count one, weapons carrying concealed, that you did carry a dangerous weapon, to wit, a pistol, concealed on or about your person contrary to MCL 750.227. This is a felony punishable by up to 5 years in prison and or fines of $2,500 plus court costs. There's count two, assault with a dangerous weapon, felonious assault, that you did make an assault upon Renell Anderson with a dangerous weapon, to wit, a pistol, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder, contrary to MCL 750.82. This is a felony punishable by up to 4 years in prison and or fines of up to $2,000 plus court costs. Count three, weapons, felony firearm, that you did carry or have in your possession a firearm, to wit, a pistol, at which time you committed or attempted to commit a felony. Contrary to MCL 750.227B, this is a felony punishable by up to 2 years in prison, to be served consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. Inasmuch as you are not represented by an attorney, this court will have you stand mute to the charges against you. There is a request from the Van Buren Township Department of Public Safety that your bond be set at 5,010% and that you have no contact with Renell Anderson, Renell, and that you do not return to 42034 Freeport in Van Buren Township. What say you as to this bond recommendation?
Can you repeat that, please?
There is a bond recommendation from Van Buren Township Department of Public Safety that your bond be set at 5,010% and that you have no contact with Renell Anderson, that you do not return to 42034 Freeport in Van Buren Township. My question is, what do you say in response to this bond recommendation?
Yes, ma'am.
Yes, ma'am, what?
About the bond?
the bond, yes,
And not
ma'am.
returning to that address.
And never returning to Renell Anderson's address, ma'am.
Your bond is set at 5,010%. You are to have no contact with Renell Anderson and do not return to 42034 Freeport in Van Buren Township. The next step in these proceedings will be your probable cause conference that is scheduled for July 13th, 2022 at 8:30 a.m. with me in courtroom number 1. Again, for the record, this case number is 220490FY. Next court date is July 13th at 8:30 a.m. Anything else?
No, ma'am, nothing else.
Anything else, Van Buren?
No, ma'am, thank you.
We're all set. Have a good day. Good luck to you. I'll see you on the 13th.
Yes, ma'am. Thank you.
This is 221521LT. This is Bill Villa Lake versus Julie Langer.
Mark Land on behalf of plaintiff. Good morning again, Your Honor.
Good morning again, Mr. Landau. Today is the day and time set for hearing on plaintiff's request to lift the SARA stay that was entered back on April 27, 2022. 69 days have passed since entry of that stay. This matter was scheduled for 10:30. It's now 11:08 a.m. by the court's clock. Defendant has failed to appear. Mr. Landau, how do you wish to proceed in this matter?
I've got good news for the defendant, Your Honor. We are going to dismiss the case. That appears that Sierra has now paid out. And so there is no basis to proceed forward.
Thank you, Mr. Landau. Make an indication on the file that a dismissal is forthcoming. Anything else in this matter, sir?
Nothing else on this matter, Your Honor. I did have a 9 a.m. matter. I did check in on that at 9:30, but I was having some technical issues. That was Belleville Meadows versus Justin Awad.
That the substitution of attorney was signed And Mr. I
Was
can't
Aaron
remember
Cox
whose
that
office
subbed
it
in?
is. The matter has been handled in its entirety.
Very good. Okay, thank you, Your Honor.
Thank you, Mary Ann. I have to step off for just 1 second. Gentlemen, give me one moment, please. My apologies, Mr. Morton. This is 221750 LT. This is GI versus Robinson. Mr. Morton, the court notes your appearance for the record. Today is the day and time set for hearing on plans request to lift the Sarah stay that's been in place since May the 4th, 2022. 62 days have passed since entry of that stay. This matter was scheduled for 10:30 a.m. It's now 11:11 a.m. by this court's clock. Defendant has failed to appear. Mr. Morton, how do you wish to proceed?
Here at this time, we would move forward to seek entry of a default judgment for possession. Was it a payment was received from Sarah for $3,051. However, as of today's date, rents retained still remains $2,512.76. Court costs of $167. We're told $2,679.76. We would ask the default judgment for possession to be entered.
Inasmuch as defendant has failed to appear as directed by this court, the Sarah stay is hereby lifted. Default judgment shall enter in favor of plaintiff and against defendant with rent to retain of $2,512.76, $167 in court costs for a total judgment of $2,679.76. This is 221768 LT. This is GI versus Brandon Frederick, Joseph DeSaltils, and Elizabeth Fitch.
Your Honor, was it based on the party's failure to appear? We would ask a default judgment for possession to be entered. They have made payments themselves individually, which were made at the beginning of May. However, at this time, rents retained remain $3,331.00. Court costs of $211. We're told $3,542.00. We would ask a default judgment for possession be entered.
Thank you, sir. The matter is scheduled for 10:30 a.m. It's now 11:12 a.m. None of the three defendants appeared this morning based on their failure to appear. The Sarah stay is hereby lifted. Default judgment shall enter in favor of plaintiff and against defendant with rent to retain possession of $3,331, $211 in court costs for a total judgment of $3,542. Plaintiff's office to submit that judgment for entry. This is 221769 LT. This is GI versus Ariana Payne, Juan Nealand, Jamie Abdullah, and Charmaine Woods. Mr. Morton, this court notes your appearance for the record. Today is the name time set for hearing on plaintiff's request to lift the Sarah stay that's been in place since May the 4th, 2022. 62 days have passed since entry of that judgment. Matter was scheduled for 10:30 a.m. It is now 11:13 a.m. by the court's clock. Defendants have failed to appear in this matter. Mr. Morton, how do you wish to proceed?
Your Honor, at this time, we would ask a default judgment for possession be entered. For the record, $1,000 has been paid since the entry of the Sarah stay. However, there still remains a balance due of $6,053.48 for rents retained, court costs of $233 for a total of $6,286.48. Again, we would ask a default judgment for possession be entered.
Matter scheduled for 10:30 a.m. It's now 10:14. Matter scheduled for 10:30 a.m. It's now 11:14 a.m. by the court's clock. None of the four defendants appeared this morning. This court will lift the Sarah stated previously enter default judgment in favor of plaintiff and against defendant with rent to retain possession of $6,053.48, $233 in court costs, for a total judgment of $6,286.48. Plaintiff's office to submit that default judgment. Mr. Morton, was that your last case, sir?
And I believe that's my last matter, Your Honor.
Thank you so much. Have a wonderful afternoon.
You as well, Your Honor. Thank you.
Thank you. This is 222622 LT. This is Bill Properties versus Allison Robinson. May I have your appearances, please?
Jarrett Levine for the plaintiff. Good morning.
State your name for me, please, Ms. Robinson.
Allison Robinson.
Thank you. Mr. Levine, when Ms. Hart was here on your behalf back on June the 22nd, 2022, Ms. Robinson indicated that she vacated the property on June 6th. Ms. Hart was going to verify that information. This matter would possibly be dismissed. Where do we stand this morning?
I don't have information that she vacated and they have us proceeding on a balance. Where did you turn? I didn't have a chance to speak with Ms. Robinson in a breakout room either. So, but no, I don't have information that the property's is vacant this time. And our request is.
Ms. Robinson, was that the information from the hearing on June the 22nd that you moved out on June the 6th?
Yeah, I had moved out. I returned. I had talked to the property manager. Told him I had left. I vacated the premises.
Ms. Robinson? I'm sorry, I'm interrupting you only for 1 second. Mr. Levine, did you want to speak to her in a breakout room or did you want to contact your client?
I'd like to do both if possible. If you could get us in a breakout room and I'll make a call and see.
Absolutely.
Return.
Ma'am, please join the attorney in the breakout room. You're going to breakout number 1.
Thank you.
Okay.
Thank you. So Mary Ann,
Yep.
the Romulus Animal Shelter once again has a plethora of kittens.
Oh, no. Ah.
Saved by Mr. Levine and Ms. Robinson. You had an opportunity to speak in the breakout room. How are we proceeding, Mr. Levine?
Thank you. I've confirmed that the apartment, they got the apartment back on Friday. And we moved to dismiss the case without prejudice as to all parties, all claims. There's still some's doing owing, but our case is for possession only. There's no supplemental claim for money damages. So we'd voluntarily dismiss without prejudice. Hopefully the parties can work something out before it gets to collections. And if not, the account could still end up there.
Any objection to the dismissal, Ms. Robinson?
Okay.
Thank you. Mr. Levine, if you submit it by email, the court will enter it. Ms. Robinson, have a wonderful day.
I'll send
You
you an
too.
email. I'll send the court an email with the dismissal. Thanks.
Thank you.
Bye-bye.
This is 222322 LT. This is BC Belleville Manor versus Nathan Luckett. Mr. Levine, the court.
He left.
Oh.
Is there a phone? Do you have a phone number on the file? I can call him really quick. If not, I'll look him up.
248-851-8000.
Okay, give me 1 second.
That was funny.
I'm on hold with his office, but he has the last one too, doesn't he, Watts?
He has two.
Okay.
Yes.
It's our last two, right?
Of course it is. Why wouldn't it be?
So I'm laughing, of course.
It's fine. Stamp prices are going up again. Stamps are going up to 60 cents as of July 10th.
Sorry, I was talking with someone at his office. What did you say?
Stamps are going up to 60 cents per.
Oh my
stamp
God. Oh, that's kind of sad, isn't it?
As of July the 10th.
Aw. Well, just because. He's coming back.
As someone who regularly sends correspondence, I keep a coil of stamps, and so when it goes up, I'm always like, I can't keep track of it. I can't keep track of what they are per stamp anymore. Mr. Levine, this is 222322 LT. This is Belleville Manor versus Nathan Luckett. We were last here on June 22nd, and Ms. Hart and Mr. Luckett asked this matter to be adjourned. Do you have any update as to this matter?
I don't have, okay, help me out. Belleville Manor. And the last name again?
Luckett, Luckett.
Dismissed. That case is dismissed. And hopefully they sent you a dismissal. If not, I can send you one. But that Luckett file should be dismissed.
I haven't received one, but this matter was scheduled at 11 a.m. It's 11:27 by the court's clock. Defendant failed to appear. If you want to send a dismissal over, I appreciate it.
Very good.
And the last one
Yeah.
we have is 222550 LT. This is West Village Estates versus Courtney Watts. The case was last here on June the 22nd. The defendant appeared but did not stay through the time that the case was called. Ms. Hart was here and we adjourned the matter to today. Matter was scheduled at 11 a.m. It's now 11:27. Do you have any update as to the status of this matter, sir?
Yeah, West Village versus Watts is also dismissed according to my records. And so I would move for entry of a dismissal without prejudice as to all parties involved.
Thank you, sir. That now concludes this court's docket for the morning. Thanks for coming back on. Have a wonderful day.
Thanks, and sorry for logging off. I didn't realize I had those others that didn't get dismissed. Apologize. I wouldn't
It's
just
okay, no
I wouldn't
worries.
just log off and leave you without these files. But thank you for calling me. I appreciate it. Have a nice rest of your day.
Okay,
Bye-bye.
you too. Bye-bye. Mary Ann, thanks for getting him back on. It's 11:28. Have you seen anything else from Andy?
No, I have not.
We'll go down. If something comes in late, we'll just